The return of my Coin Lady channel brings me much joy. Here in this video, I'll give you attorney John Deaton's take on yesterday's news that the SEC will be appealing Judge Torres' decision in the Ripple case. This is fascinating to me because John Deaton was pivotal to the XRP community's involvement in this case. He pushed himself into it, court-approved tours to take part, and represented more than 75,000 XRP holders worldwide. Additionally, he is currently swamped with work. Here, I know you heard, but I can't say for sure. While he is currently in the midst of his Senate campaign, he spared no time to offer his thoughts on the events surrounding this case. So, I'll summarize his assertion, offer some commentary, and cite or otherwise make reference to some of the specific examples he uses. For example, the fact that Bitcoin was formerly discovered to have been a component of an illicit securities transaction is not necessarily well known. Was that even known to you? Well, I've already covered that ground on my channel. It may or may not be very common, I am not sure. I was unaware of that until Deaton began mentioning it in the past few years, whenever he initially brought it up. I was taken aback by that. I take it that this isn't enough to classify Bitcoin as a security? Give it a go, please. Okay, so here's where lawyer Deaton writes his post. The choice to challenge a district court verdict is something that, in his opinion, a U.S. Senate candidate would typically keep silent about. On behalf of 75,000 token holders, I fought severe overreach and wrongdoing at the SEC in this specific instance, and I spent over $75,000 of my own money and hundreds of hours pro bono fighting it. But I'm not your average candidate. Alright, I'll pause to mention that I was aware this was bound to happen, even though it cost him time and money. He's had his own law business supporting him, and there's a lot on his plate. Maybe I'm simply forgetting or completely disregarded the fact that he has before mentioned that figure. However, I recently became aware of that. I was like, oh my freaking god, $75,000 to kind of if you think you could think about $75 grand to pay for, the privilege of fighting the SEC, if you want to call it that, and spending hundreds of your own hours that cost 75 grand, you gotta appreciate John Deaton and the amount of fire in the belly, as they say, that you must have to do something like that, because it can't be an emotion that's a flash in the pan if you have. To have that persistent feeling throughout to go to the length that he did, and I just think it's incredible that he has pulled this off, and he absolutely materially changed the outcome of this lawsuit because there were sworn affidavits from XRP holders thanks to him in the lawsuit that were referred as a result. It is quite remarkable. But I was like, whoa, 75 grand for that when I saw that price after reading this. Myself, I am convinced. I'm only stating it because it hits home, especially when you consider the gravity of his actions and the outcome of the case. I'm aware that there is an appeal that is separate from this one, but in the end, it won't affect XRP holders anyhow. He goes on from there. To paraphrase, all he wanted the SEC to do was confirm that XRP wasn't a security in and of itself. The request was not very ambitious, given that Judge Castell had already determined via telegram that the Graham token, similar to Bitcoin, was merely a string of letters and not a security. Alright, I also need to pause to address that. Now that we know that XRP isn't a security, it's just code, and that the SEC's arguments about its lack of intrinsic value were baseless, will they even appeal this decision? Their argument was that. Okay, I'm going to paraphrase a bit, but that's basically it. What do they say, though, during the course of the case? So, are you implying an additional layer of protection if you ask them directly? Their hypocritical behavior was on full display as they contradicted themselves time and time again. This led them to the unfortunate situation where they continued to deny the need for additional security measures, even after the decision had been made. Had they been more forthright from the start, they could have avoided John Deaton's 75,000 XRP holders, who significantly impacted the outcome. Naturally, if that were the case, and I'll explain why, they wouldn't have acted dishonestly and then made the same arguments. You would be lost to them. Therefore, they chose to act in an intellectually dishonest manner and attempt to destroy everything. With the advantage of hindsight, isn't that really ridiculous? things didn't turn very well for him. In any case, Deaton keeps going. Beyond that decision, 75 years of case law made it crystal clear that anything could be packaged, marketed, offered, and sold as a security. What never was the security was the underlying asset or thing. This includes condos, Bitcoin, chinchillas, and orange groves, among other things. Neither Bitcoin nor condos were transformed into securities in the process. Anyone can buy beavers as an investment contract. They don't change into unregistered securities, they stay beavers. That being the case, it is patently accurate. Even if someone unlawfully packaged and sold XRP or Bitcoin as a security, it wouldn't change the fact that it is a cryptocurrency. Thus, I once again, as previously mentioned, the exterior of the film. Many individuals probably aren't aware of this. I know I brought it up on my channel before, but I figured this would be a good place to go into further detail. Bitcoin was definitely offered and packaged as a security. Your attention in seeing my video is greatly appreciated. When you're done, hit that subscribe button and let me know what you think.